Wanted to give a quick update on the A-Rod lawsuits. We've talked about his 2 lawsuits against Major League Baseball, his challenge to the arbitration decision, and he finally waved the white flag. We talked about on the show, these cases were a case of wishful thinking. He had no realistic chance of prevailing. And then finally, he just dropped the cases. And so he'll be serving a suspension for the next season, 2014 season. And
He's dropped all the lawsuits?
He dropped them. He dropped both of them. The first one he filed after he was initially suspended by Bud Selig. And he took the offensive against Major League Baseball because Major League Baseball, in order to acquire evidence, had sued that company up down in Miami that had been allegedly the supplier of banned substances to A-Rod. And this was the subject of a 60-minute segment. They interviewed the guy who says that he supplied and actually injected into A-Rod the substances. So that case was pending, and then the arbitration went forward, and the arbitrator reduced the suspension from 211 games to the 2014 season plus playoffs, and then arbitration awards are extraordinarily hard to set aside. You basically have to show a payoff to the arbitrator by one party. Otherwise, the parties negotiate for an arbitrator's decision, not a judge's decision. Notwithstanding that, A-Rod, being unrealistically optimistic, filed an appeal from that decision. That was case 2. I had a feeling that the judge who had these cases had a bit of a skeptical eye, and Major League Baseball said the cases should be dismissed. There seemed to be no way that I could see where these cases were going anywhere. And ultimately, I think A-Rod and his counsel got to the point where they accepted the inevitable and dismissed the cases. So this saga is over. A-Rod's out for the year. The lessons here for entrepreneurs, of course, are these. One, if you have an arbitration decision, which has arbitration clauses are very common, they will be enforced, and they create a different means of resolving your disputes. One of the advantages are speed. One of the advantages are efficiency, diminished costs. Negatives are they're basically non-appealable, except in the most extreme cases, unlike court. So think about whether in your contracts you want to have arbitration clauses as a way to avoid the long, protracted, expensive litigation, but understand that the decision of the arbitrator is going to be final, no appeal. It's not just a recently filed case. I didn't file it, but not involved, but I thought it would be interesting here. The MBTA, Massachusetts Bay Transit Authority Retirement Fund, made a $25 million investment in a hedge fund. And this has been the subject of some media stories because it appears that the investment was worthless. So the MBTA has recently, the retirement fund, has recently brought suit against accounting firms and valuation firms that perform services for the fund. So you go into an investment, there's a prospectus, a subscription agreement, you get these financial statements. Audited financial statements are a good thing to get if you're considering an investment. But what if the investment is not correctly represented on the financial statements? What if the information that you're provided is inaccurate? So there you are, the MBTA alleges it lost $25 million. It's pretty upset, brings suit against accounting firms and evaluation firms. And the theories are one that, the work was technically provided by these companies to the hedge fund. However, the expectation was that this information would be furnished to potential investors. So can the investors sue the accounting firms and the valuation based upon alleged mistakes in the valuation and mistakes allegedly in the financial statements?